So we're really lucky to have had a panel that we put together at the Auto Intel Summit that featured Rod Arends from Southeast Toyota moderating, along with Becky Kuehn from Hudson Cook, Mary Ross, who wrote the California Privacy Act, and David Lincicum from the Federal Trade Commission, reminding us the importance of data security. And it's a 45-minute video, roughly. So what I'll do is go ahead and we'll put a slide up, as you can see here, that focuses on some of the key points if you want to hop ahead and just look at certain content that's related to CCPA. Our focus is on debt collection. So it's really, what does the CCPA mean to anyone that's gathering and using data in debt collections, and how does that apply?
All right, thank you very much. And of course, I have to thank Bill and the entire Cherokee media staff for putting on another great summit. Thank you very much. We've got some great information. I think there'll be a lot of interest for a lot of different people in different roles as we go through. A little bit of background on me. I've 32 years in the captive auto finance business. I've been with Southeast Toyota Finance now in service center operations for the last 12 years. Great organization, regional lender in the 5 Southeast states. On the panel today, we're going to talk about data privacy, sort of crossroads with regulatory oversight and debt collection. So all of you have seen the news, a lot of information out there, a lot of opinions on what's covered, what we need to do as lenders, what data providers need to do, what responsibilities you have when you house that data, et cetera. And that's a lot of the information that we'll cover today. On the panel, we've got Rebecca Kuehn from Hudson Cook. She's a partner with Hudson Cook. John Lewis probably needs no introduction, but he's CEO of Intelligence Master Q. We've got David Lincicum, who's with the FTC, Attorney General. And we have Mary Ross, who's with MSR Strategies, also a co-author of the California Consumer Privacy Act. So one thing I will share with you before I hand it over to Mary, she's going to go through her slides first, but if you were in the session yesterday, they talked about Face App, and I thought I would take a shot and upload my selfie and see what that looked like if I aged. Well, I uploaded my selfie, the little cursor spun, and then the GPS voice came on and said, "You've reached your final destination." So I think there's a bug or something in there, I'm not sure. But on that note, I will turn it over to Mary. So Mary, if you want to go up to the stand.
Hi, thanks so much for having me here today. My name is Mary Stone Ross. And I was a co-author of the CCPA and one of the architects of the initiative that became the California Consumer Privacy Act. So a little bit about my background. I started actually as a CIA and counterintelligence officer, so I joke I actually approached privacy from the opposite side. I was a spy. After living and starting my career in Washington, D.C., I was also counsel on the House Intelligence Committee. About 4 years ago, we relocated to California for my husband's job. And so with the initiative, it was kind of a fluke. I met Alistair McTaggart, who is the real estate developer who came up with the idea and who funded it socially. And he had this idea after meeting a drunk Google engineer at a party and said, "Oh, all this privacy stuff, is it something that I should really be worried about?" And the engineer looked at him and responded and said, "Oh, if you only knew what we knew about you, you wouldn't be able to sleep at night." And so he had this idea to do something on privacy using the initiative process, but he still has his real estate firm, so he needed someone to kind of dig into it. And so it was kind of perfect. I'm a policy person and I'm a lawyer, and so that was 3.5 years ago, and then here we are today. So I know it's been in the news a lot, but just the high-level overview of what is the California Consumer Privacy Act. It has 3 main pieces of it. It will go into effect on January 1st, 2020. So the first, it's a right to know. So we'll grant any Californians the right to find out what personal information a business is collecting about them. And so it will be both the categories of personal information a business collects, but also there's the right to find out the specific pieces of personal information. The second is a right to opt out of the sale of personal information. So if a business is selling your personal information as defined by the CCPA, then a Californian will be able to say, "Please do not sell my personal information," and that right will have to be honored. And then finally, there's a right to delete personal information. This was a piece that was added in the legislative compromise. And so there's actually quite a few exceptions to the right to deletion. So just a little bit of how do we get here? The myth I hear all the time is, oh, the CCPA was written and passed in a week. That's not true. It was actually a 2.5-year process of writing the legislation, meeting with different stakeholders, so both the privacy advocacy groups, but also with some of the major tech companies. The actual negotiations with the legislature started in the spring of 2018, and then it was passed by the legislature in Sacramento on June 28th of 2018, so about a year ago. There's a process to amend the CCPA. Nothing has been signed into law yet, but that legislative session will recommence on August 12th, and they'll have about a month for those amendments to go through before the CCPA goes into effect in January. You can get the whole deck from John, but these are some of the differences between the initiative version of the CCPA and the actual CCPA, and I think it's where some of the confusions of how the law is to be implemented. So what is personal information under the CCPA, and who is a business from California consumers by businesses? So there are no restrictions onto the actual collection of information. A business is still free to collect whatever information they wish to, but if a Californian wants to find out what information it collects, then that will have to be disclosed. Again, the definition of personal information is much broader than what it's been in past legislations, and it covers a lot of different categories, including IP addresses. Also, the CCPA, the reach of the CCPA is well beyond the state of California. The nexus is a California consumer. So if a business is collecting information about Californians, then they will be covered under the CCPA. And again, it's only for for-profit entities. It is not for non-for-profits. And so this is just, again, you can get this from John, but this is the statutory definition of a business in the CCPA. So it has an annual gross revenues of more than US $25 million. It holds the personal information of 50,000 or more California consumers, and it makes at least 50% of the revenue from selling consumer data. And with this definition, you only need to meet one of the criteria in order to be covered under the CCPA. So the first piece of the CCPA and the real heart of the law is this right to know. And so what it covers is that the categories and the specific pieces of personal information, so the categories are listed in the bill, and it's one of the areas that the Attorney General also has oversight over, that they can, in fact, every year add to what a category of personal information is under the CCPA. Also in the right to know, there has to be disclosed the categories of the sources of personal information that's collected, the business purpose for collecting that personal information, and then the categories of third parties with whom that personal information is being sold to or shared. Under the CCPA, a Californian has the right to opt out of the sale of their personal information. And so how that's done is the Attorney General, again, will come up with what a button looks like, but a consumer will be able to press a button on a homepage that says, "Do not sell my personal information." And once that Californian consumer presses that button, then that business will be prohibited from selling personal information. Enforcement. So one of the legislative compromises was taking out a broad private right of action that was in the initiative form of the CCPA. So right now, as written, the Attorney General of the state of California is the primary enforcer of the CCPA. Their office has come out and said that they expect that even with additional resources that they have received, they think they'll only be able to bring 3 enforcement actions per year. Under the CCPA for data breaches, and it's a much smaller set of what personal information is covered under a data breach, but if a business fails to implement reasonable security practices and certain categories like your social security number are breached, then a Californian can bring a private right of action under the CCPA. But I just want to say that this standard of reasonable security practices is existing California law. The only difference is the ability of an individual to bring a private right of action. So finally, the legislative changes that have been proposed, they were all proposed this year. The way Sacramento works is that it's a 2-year legislative calendar. So even amendments that do not go through this year may in fact come back to life in the spring. The only difference is the CCPA will go into effect in January. And so any changes that are made after that will be changing a law that's already on the books. So some of the ones that I'm following fairly closely is one that exempts employee information from the CCPA. So as written, employee information is covered, but this would say that, oh, I as an employee cannot go to my employer and say, what do you know about me? That would be an exception. That amendment is likely to pass, but it does have a 1-year sunset provision. And so that's something to, that I will be paying particular care about. Other amendments are looking at changing the definition of de-identified. Right now, there is an exception for the sale of de-identified information, but there is a big fight over how to define that. And then there is a law that was introduced to reintroduce the broader private right of action for the CCPA. It's kind of killed politically, and I don't expect that to come back to life, but I think that there might be some pressure to expand enforcement of the CCPA going forward. And just for a calendar note, the session ends on September 13th, so we'll have a very good sense then of what bills the governor will sign, and so what the CCPA will in fact look like in January when it goes into effect. Okay, now.
I told Mary she had the hardest job. My name is Becky Kuehn. I'm with Hudson Cook. I head up our credit reporting, privacy, and data security practice there. Before I came to the FTC, I was in-house at a data analytics company for a couple years, and before that I had the privilege of working with David here at the Federal Trade Commission. But my focus has always been on sort of the use of consumer data. So in working with clients under this act, it is big, it is complicated, it is far-reaching, it likely touches aspects of your business. And so one of the things I wanted to focus on are sort of where are some of the saving graces, which is the exceptions. But I was really impressed with how fast Mary got through it. I did a client presentation on Monday about the CCPA. We went 90 minutes and ran over. So it's a lot, it's a big bill, there's a lot of pieces to it, but we're gonna focus on the one that's probably the most important to the folks in this room. There is an exception, and you still have a responsibility under data breaches. There's still a private right of action there. But for all these other responsibilities, the right to delete, the right, the requirement to provide information to a consumer about what information you have on them, there are some exceptions that apply to those requirements. And the biggest one that really touches this industry is the exception for data that's under the Gramm-Leach-Bliley Act that qualifies as personal information. Now, as originally enacted, there's always been a GLBA exception, and I'm sorry for using acronyms, but it's a lot shorter to say. There was a GLBA exception, and it talked about the data that the laws that kind of conflicted with the GLBA. But if you knew GLBA and the way its preemption works, it was kind of an unholy mess to figure out what was in and what was out and what was excluded. So there was one correction to the bill that's passed. This passed actually, September of last year, I think it was, to basically clean up the exclusion. And so essentially, if you've got personal information that's covered by the GLB or the California Financial Information Privacy Act, then that information is exempt from the coverage under the CCPA. And it's important to think of it as information. There are a lot of laws out there, some data broker laws, that exempt financial institutions under GLBA. That's an institution-based exception. This is an information-based exception.
So the point Becky just brought out, I think, is probably the most misunderstood point that I've seen in talking to multiple different people in regards to the GLB exemption that's listed in the CCPA Assembly Bill number 375. And the language clearly states that it's the data. It's not the fact that the company falls under an exemption because they are governed by the GLB. It specifically relates to the data. And one of the things I think that's key about that is as we talk to the multiple data providers, they're trying to separate out what's GLB, what's non-GLB, but it's not always that easy to separate out. And a lot of times, it could be data that you're getting off the internet, it could be social media data, it could be personal property records. A lot of things are not going to fall under GLB. Our position is track everything. If you're going to track everything, and if the consumer wants to know what do you have, you've got the ability to share with them what you want or don't want. If you don't know exactly what's GLB or not, share it all with them. If you want to delete it or not, that's up to you. You decide how you want to handle the consumer's data. But the most important thing is tracking all that data and tracking it in a way that you're going to be able to easily grab it and know exactly what you have. It's in structured fields. It's not buried in some notes. It's not in a PDF. It wasn't copied and pasted into your system. It's all being gathered in a fully trackable manner so that you know exactly what you have, and you're able to look your consumer in the eye and tell them exactly what data you have on them and what do you want to do with it. That, I think, is the most important point about this whole data privacy issue and laws and the different ones that are coming. As you can see, there's a lot of different states that are now putting out laws, and they're all going to be a little different, and it'll take a couple years till the Fed kicks in and decides they want to have a national law. And even when they have a national law, we have a National Fair Debt Collection Practices Act, but we also have multiple states with different rules that we have to follow too. So I think the most important key to this is what type of technology you're using, and is the technology able to gather, organize, and track all of the data that you're using on consumers as it relates to their the protection of their data and how you're using it for data privacy.
So you can be a financial institution under GLBA and still have data that is going to be covered by the California Consumer Privacy Act. And so it's very important to sort of remember that when you're thinking about your business and whether or not you have a risk of coverage under this law. One thing we've been focusing and working with clients on is looking at this exception and what is information. I think we all have privacy notices. We give our privacy notices. We treat certain sets of data as covered by the GLB. But I think that there's going to be a little bit more of an increased focus here on, is it really GLB data or is it not? So I thought it'd be helpful to take a few minutes and focus on what data constitutes GLB data. So to be personally identifiable financial information that's covered by the Gramm-Leach-Bliley Act, it either has to be data that a consumer has provided to you to obtain a financial product or service, about a consumer resulting from your transaction. So think about your transaction and experience data, payments consumers make, information like that. Or that you otherwise obtain about a consumer in connection with providing that financial product. There's a separate exception for information under the Fair Credit Reporting Act, but you kind of get a double coverage here. So to the extent, for example, you're pulling credit reports in connection with a loan application, you're obtaining other information in connection with a loan application, all of that information may be personally identifiable financial information under the Gramm-Leach-Bliley Act. It's important to note, though, that GLB has a purpose exception. It has to be data that you're getting in connection with or resulting from this transaction. So let me give you a great example. You have an online lending platform. You're collecting IP addresses, which, as Mary told you, are covered under CCPA. Are you getting those IP addresses in connection with the financial product or service, or are they for some other sort of purpose? And so I have clients sort of taking a look at the data that they capture at various points in time and seeing whether or not it's related. For a lot of lenders, for example, and a lot of auto dealers and others, they're collecting that IP address in order to do what is essentially sort of a fraud prevention, right? They want to make sure it's a legitimate application. There's a rational relationship to the particular transaction. So we would think of that data as being covered by GLB. But if you're capturing it, for example, to see where your marketing traffic is coming from, and it has nothing to do with your financial transaction, well, then it's going to be outside. And so that's fair game under the CCPA. There are some other exceptions. I did want to mention these because I think they're very important. There is a current exception for data that is the sale of personal information to or from a consumer reporting agency. Among other legislative efforts, there's been a discussion to try to clean up that amendment a little bit to help, a concept of furnishing, which doesn't usually exchange, you don't usually exchange money when you furnish data to a consumer reporting agency. So that we're kind of working through the legislative process there. Driver's Privacy Act. So similar to that discussion we just had about GLB data that's collected, processes, sold, disclosed, all that good long list. Under the Driver's Privacy Protection Act, so think about your DMV type data. That's data that's going to be exempt, except for, of course, the breach provision. And there's some other things Mary talked about de-identified and aggregated information, data that doesn't really identify a particular consumer. But for this group, I think really it's the GLBA exception that's the most important. And I think that's where we're going to see a lot of focus and attention to knowing what you have and what you can do with it. So with that, I'm going to turn it over to David.
Hello, I'm David Lincicum. I have been at the FTC for 13 years now. I work in the Division of Privacy and Identity Protection. We handle a lot of data security cases, some privacy laws, and related things. I came right as the division was formed, so my time there has been exclusively at, we call it DPIP. And over the last few years, I've sort of become in charge of GLB. And so today I'm going to talk about some proposed rules, but before I start, the ever important disclaimer. Everything I say here is me, not the commission itself. So in other words, if I say something stupid, that's me, not the commission. All right, I imagine a good number of you, or most of you, know about the safeguards rule under GLB. Real briefly, GLB has two components from a regulatory standpoint. There's the privacy rule, which governs notifying consumers of the information you're collecting and how you're going to use it and giving them a chance to opt out of some of those uses. And the other half is the safeguards rule, which says to financial institutions you have to provide proper safeguards for information you collect from your customers. The current rule has been in place since 2001, which is approximately 300 years in internet years. So we've decided it was time to change things a bit and update it in order to give a little bit more guidance to financial institutions and to give us some other enforcement tools as well, obviously. What we're trying to do is keep the flexibility of the current rule, which basically says to you, you need to have a program, you need to have someone in charge of it, it needs to be reasonable, it has to be based off of a risk assessment process, and you have to take care of your service providers. Make sure that they are able to take care of the information and that you have contracts requiring them to do so. So we wanted to give that a little bit more meat on the bones so that companies knew what they needed to do to have a reasonable data security program, but we wanted to make sure it retained the flexibility so that it gives you a lot of room to decide how you're going to enact it. And I should say it is based on New York cybersecurity regulations, which went into effect in early 2017. We saw that, reviewed it, thought they did a really good job, and we went and based it on that. We've made quite a few changes, but the bones of it are similar to New York's rule. So it's still, as I said, based on making a comprehensive information security program, and it needs to be suited to the size and complexity of your company. So it depends if you are a small company with very little information and say you don't collect very sensitive information, so you only get email addresses and maybe names, you will have a different level of security than someone who collects a complete financial dossier on someone. If you have their social security numbers, their credit history, all that, you need to give it a greater protection. But at the end of the day, this proposed rule puts more detailed requirements there than what it had before. But as I said, they're all process-based and adaptable. It's about looking at this area, deciding what your company needs to do to properly protect it and taking the steps necessary. And there is an exemption from some of the requirements if you have a company that has less customer information. We didn't based on the size of the company because, as you probably know, a company with a very small company can still get its fingers in a lot of data these days. So a company that, even if they're very small, is handling thousands or millions of customers' information will have to still comply with the entire rule. So the first thing you need to do is have someone in charge of the program. There needs to be someone who's responsible. We call it the CISO, the Chief Information Security Officer in the rule. A person doesn't need to have that title. They don't need to be of a particular rank or anything. We just use that as a name for convenience. You have to do a written risk assessment to say, what information do we have? What are the risks to that information? And how great is that risk, and how can we mitigate that risk? And then you have to continue to do that periodically when things change. Which is kind of constantly, but you need to make a decision on your business, how often that needs to be. And then you have to test it. You have to actually make sure that the safeguards are working. And you can do that through some form of continuous monitoring, where you always know so you have a constant idea of what's going on, or annual penetration testing, or biannual vulnerability assessments. There's a fair amount beyond that, but they are generally just going into specific things that you need to consider. There are two elements, though, that are more specific than the others and tend to be a little bit more prescriptive, and that is encryption and multi-factor authentication. In both of the cases, it's generally required, but if your CISO looks at it and says, this is not possible for our business, or it's not appropriate for our business, they can come up with an alternative way of protecting the information. But there does need to be some sign-off by the CISO. And there's still a great deal of flexibility in how you implement it. So the encryption rule would require that all your customer information, and that's something I should point out about the safeguards rule, is it only applies to customer information, not consumer information. So it's information for people you have a customer relationship, an ongoing customer relationship with, or information of customers of the financial institutions that you receive the information from. And it requires, for that customer information, that you encrypt it both in transit, outside of the network, so if you're sending it outside of your network, or at rest in your network. So again, only applies to customer information. The transmitted information, it does not apply internally, only when you send it out. And again, the CISO has an opportunity to come up with an alternative. But we do think that in the current environment, financial institutions really need to be encrypting their customer information. It's not really an optional situation anymore unless it really does not work for your business. Multi-factor authentication is kind of the same way. There's still a fair amount of flexibility in adopting it, but you need to have multi-factor authentication for any individual who wants to access the customer information. You may be familiar with the general concept of multi-factor authentication. I think it's fairly common now. We have, I think, a fairly standard definition that will be recognizable to people who've dealt in the area before. But basically, multi-factor authentication says if someone is coming into your system, you need to verify who they are using 2 of 3 possible factors. There's the knowledge factor, which is things you might know, like a password or biographical information. There's possession factor, things you have, like a little security token, or possession of a particular phone that you verified belongs to that person, or another other kind of device. And then there's the inherence factor, which is still fairly uncommon, but increasing in how often you see it, which is things you are. So voice prints, fingerprints, retina prints, that sort of thing. And again, the CISO has an opportunity to come up with alternative methods.
Okay, thank you very much. So a little my background, I'm not a lawyer. I'm surrounded by lawyers on stage besides Rod and I. And I started 1982 at Chrysler Credit. They asked me what I thought about repossessing people's cars, and that turned into a 30-plus year career of building a number of different businesses, working in different environments within Chrysler. Mitsubishi helped them get their finance company off the ground. Managed a couple of local repo companies, learned about being an entrepreneur, met my wife. She said, why don't we start our own business? And we're on our 9th one right now. One of my partners at MasterCube built a company called CoreLogic, and one of the things he taught me as we were starting to gather and build data around skip tracing was how important it was to be able to really look at how you gather, organize, and track data. And ironically, as we talk about these rules and these laws, how prophetic was he to be able to say that when we were thinking about it from an efficiency play, and now it's a data privacy and a security and a regulatory play. So here you got the lady who wrote the law. Here you've got the guy who's enforcing the security of the data. So she's telling us what we need to do. And if you listen to Mary's podcast on the International Association of Privacy, what's it called? professionals, which I encourage everybody to join because it's very reasonably priced and a wealth of knowledge. When you start hearing about companies buying pregnancy result tests to see if their employees are pregnant or not, that starts to tell you about the depth of what companies are doing and people are doing with data. And I don't think anybody in this room is going to that degree or to that level, but it's all of our data. And it's really important that we protect our data. So I think it's a good thing, but it's also it's going to be a very difficult thing to do in terms, specifically in our area, in terms of debt collection. And Becky's here to kind of help guide companies like Rods and companies like us to be able to kind of interpret, because I don't know about you guys, but I'm pretty confused. And I've been studying this for 6 or 7 months right now. And the only thing I know that I figured out was we're just going to track everything. I don't care if it's GLB or non-GLB, if you got it off Facebook, wherever you got it, we're just going to track it all. Because if you're not tracking it all, then you have potential risk. Because Becky, if I'm not mistaken, even if you have an exemption, why do you still have to track it?
Definitely still covered under, if it's a GLB exception, you're covered under safeguards and the privacy rule, so you need to know that. But you also still have, there's the right of private action related to data breaches. So if you have a data breach, you need to know whether or not you're going to have a risk of lawsuits under CCPA.
Right.
And so is it the type of data that should be encrypted?
And if you're going to create an exemption, you better be able to prove it. And if if you're not tracking it, you can't prove it.
Exactly.
Which goes back to just track it. Now, the complication of that is you all have multiple vendors pulling data on your consumers. That's where it gets complicated. So we've built a solution that I'll just give you a couple of case examples of what we do, just so you can see it can be done. And this kind of walks you through that. So our concept is gather the data automatically, use APIs into the places that you're getting the data from, eliminate this copy and paste and manual gathering and PDFs and ways that's untrackable and unsearchable to be able to find the data. Organize it in an efficient manner to be able to increase your right party contacts or the reasons that you're using it for. Understand what the data is that you're getting and understand why you're keeping it. The idea that I had of bringing all these people together was to give you the best people in the industry that really understand and know these laws, because they're building them, they're studying them, they're working through it. Tomorrow, we're having a session where we're bringing a vendor on stage as part of a public company that basically has already gone in and written a lot of their policies and procedures, and she's going to talk about the data mapping and talk about the data hygiene policies they're starting to build. Becky's going to talk about that to give you guys a workshop to be able to understand how to do that. And there's a lot of people here that use our system, and for those that use our system or are interested, we're going to have a meeting from 11 to 1 to talk about how you can actually do this with the technology. And then ideally, once you gather that data and you're starting to use it, you're making compliant contact, because we're not even talking about the CFPB yet, but I'll get to that in a second, because they've also proposed new rules around 7 contacts in 7 days, or once every 7 days, or whatever else that's going to morph into. So the gather concept is simple. What we've tried to do is go out and build integrations into some of the largest platforms that are out there. Some are built, some are contracted. Most of these are built, and basically this adds the real-time integration into a single platform. It allows us to map and build mapping and hygiene policies around what data I'm using. It gives us the ability to add regulatory tracking, and I'll show you that in a second. And it gives you the ability to start playing around with data strategy. We've heard sessions about AI and about strategy and what you can do, and that's really where this generation is going to. And it's really interesting compared to the old days of skip tracing just through intuition. What it eliminates is all this manual data mining and using intuition. Not that intuition is a bad thing, because your brain is very smart, probably smarter than the computer, but at the same time, your brain also has habits of taking breaks and not calling people you're supposed to call or working as hard as you should or whatever, so that if you can automate things, it really makes it a lot easier. Copying and pasting data is, copy and pasting, why are we still copying and pasting? It's like one of those things that's just got to go away at some point. And not knowing exactly what you have is important. And then also, what are your vendors doing? Because the CFPB clearly says you're responsible for what your vendors do. If they're in a completely different system, you've got one issue that David's laws are going to start to bring up, is how complicated it is to be able to build software to the requirements of the New York law, let alone the laws that are already in place and what the banks are requiring. And I just know from running a software company how complex that is, and we're a smaller software company, which could be good, could be bad. Sometimes we're able to be a little more nimble than maybe the bigger guys are, but it's a challenge having your data encrypted at rest, encrypted in transit, going through code reviews and penetration testing, and you name it. Every single change has to be documented and written down. It's very, very complex, and it's not going to get easier. So when you organize the data, big data, everybody's big data, we got to have big data, everybody's got to have a ton of data, and that's been great for the last couple of years. All of a sudden, big data is like, uh-oh, I got too much data. I got all this data on all these people. Now there's laws coming in place that says how I got to protect it. how I got to, what do I need? If I repo the guy's car, do I still need all the data that I used to skip trace to find him? Probably not. Get rid of it. Have a policy that says what you're supposed to do with that data. And tracking is really simple. It's basically you want to be able to track, you want to track the data you're getting to determine the ROI. Becky, you said one of the clients that you had gone through a mapping policy with, what did they say about the data and the cost?
So they found out they were buying the same sets of data from different vendors at different prices, buying it twice when they really only needed to get it from one vendor. So it has some financial impacts of doing this kind of exercise.
And I think that, for those of us that have been in the data business for a long time, I see Mike shaking his head and smiling because, hey, that's kind of a known given that, hey, if you want to buy it 3 or 4 or 10 times, great. That's up to you. If you're not efficient in how you use it, but I think technology is starting to catch up to where we could be more efficient. And you really want to track the ROI of the data. So I know, you guys over there, I want to say the name of your company, but you go from 8 people to 5 people because of the way you automate the data, and your data spend went down while you decreased headcount by 3. Just because you're automating data. And it's not just have to be my system, it's any system that you do that with. Use the technology, and that's what FinTech is all about, is being able to build this technology that changes the way people use their legacy system by integrating in other systems that are a little more nimble and able to do things that's a little more efficient. Obviously, tracking all of the rules is important, and I'll show you that in a second. And then we had a case study we did, which I'll kind of really knock through this quick. Dozens of new complex state and federal laws. Every month they're changing the laws or changing the, what do you got to do? It's tough to track manually. You got multiple systems, a lot of them are legacy. We went in and collaborated with a lender. Our goal was to build an automated compliance solution, make the changes on the fly, automatically add the rules, and basically we have been nominated for an award at Finovate Fall. We're pitching our product there in our data privacy product. And as a result of, we built that law, and then we built that rule in MasterQ, and then what ended up happening, the CFPB came out and said 7 contacts in 7 days. And this is a demo basically of.
Hello all, it's May of 2019, and the FDCPA just dropped its set of rule proposal changes for collections calls. I'm going to do a quick demo in MasterQ on how our new compliance add-on can allow you to quickly adapt to the FDCPA changes. Simply going to add a compliance rule, and the rule we're going to be covering today is the 7 calls in 7 days. And this applies to both subject and co-subject numbers. So we'll go if contact type is, and let's say is our cosigner or is our subject, and this is going to be an activity base. We've made recent contacts, and the answer is 7 contacts in the past 7 days. Then what are we going to do? We're going to mask until the rule expires, and we'll just say FDCPA rule for 7 calls in 7 days.
Basically what that'll do is add the rules to all the data you buy, so as you're dynamically buying data, it's stopping you and stopping your vendors from calling people they're not supposed to call. Whether it's twice in Massachusetts or after 8 o'clock at night or whatever those are, that's what FinTech can do, which is very difficult to do manually. So with that, I'll turn it back over to Rod.
Thank you, John and Mary and Becky and David. Very, very informative. We'll open it up to Q&A. I do have some questions here, but would certainly want to give the audience any opportunity for any questions. I think, Bill, you have a mic, and there's a couple mics out there for you.
Mike, if someone has questions, raise your hands. We'll get this microphone over to you. I'll keep a lookout for that, Rod.
Okay, all right. Let's see, David, you talked about the process for commenting on the proposed new rules, the new safeguards rule. And I know you mentioned a website, but is there more involved in that process beyond that, or are you just submitting questions or comments?
Regulations.gov is the site. Search safeguards rule, and you'll eventually get there. I can't say it's the most intuitive thing. Please don't put any personal information in there or anything you don't want the world to know. If you look at the notice of proposed rulemaking that we put out a couple months ago, it has some specific questions we were asking for comments on. And in addition, any thoughts you may have. We welcome them all. We will review everything. And we want to do our best to make this a rule that will work to both protect consumers and work well with the industries involved.
Okay, perfect. Mary, I know you're focused on the California Consumer Privacy Act, but talk about what you've heard in other states. I know there's maybe 23, maybe the last number I saw had some discussion going on, but
Yeah, I think that's a little bit high. There was probably the most well thought through effort was in Washington State, and that had the backing of Microsoft and Amazon, but that did fizzle out. Vermont in January instituted a data broker registry. So any data broker that's collecting information on Vermonters, in fact, now has to register in the state. I just testified in New York. They have, I call it, it's like the kitchen sink privacy law. They took elements of the CCPA and GDPR and this whole concept of information fiduciaries and threw it all in together with a private right of action. That will be reintroduced in the fall, and I don't know politically if it has a very good chance of going through. But then I think that one of the biggest questions that's still on the table is, will there be a federal consumer privacy law, and will that preempt what all the different states are doing? And I give that probably a 50-50 chance, which may even be high. So I think, come January 1st, 2020, it still will be the California that will look for a consumer privacy law.
right. Thank you.
I'm going to mention one thing on that. I always think about California. We're like, okay, well, California is one state. It's a huge state. But if you think back to when the first data breach law was California, and now all 50 states have a data breach law. So it takes the rest of them to catch up. But California was the first one dealing with affiliate sharing of information. They kind of led the way on all these privacy issues, and so a lot of other states are taking stock of it. So we have seen legislative proposals still in fits and starts, I think, in other states, but I think there's a big wait and see to see how it works in California and what they like and what they don't, and how they might want to do it in their own states.
Okay. Mary, you mentioned GDPR, and that's the General Data Protection Regulation in the EU, and that's kind of what CCPA was sort of based on, I guess, right, or a precursor.
Well, not really.
But in the GDPR, there was a specific right to be forgotten, I guess, and I think that got a little bit of press at the time that that was out there. Does the CCPA have the exact same?
No, it is different in the CCPA. It's the corollary in the CCPA is this right to delete. It's not a right to be forgotten. But like I mentioned before, there's many, many exceptions to that deletion right. And also, just as a note of difference, in the United States, we obviously have a very strong First Amendment, and that applies to corporate free speech as well as for an individual's free speech. And I think that's why it'll be interesting to see how that right to delete ends up playing out.
Right, and that right to delete would also, the GLBA exemptions would apply to that data as well, I guess?
That's correct.
Okay.
So so essentially the exceptions, the GLBA, Fair Credit Reporting Act, DPPA, operate to exempt a company from having to sort of comply with the responsibility to provide the data, the responsibility to delete the data. And so, it doesn't get you out of the private right of action for data breaches. I'm going to keep saying that till people remember that. But it does, sort of alleviate some of those regulatory requirements.
Right.
What's the difference between you got a financial institution covered under GLB, you've got the vendor of the financial institution. Where do they fall in, and how's the interpretation of that GLB carried over to the vendor? What are the pros, cons, risks?
Sure, and David may want to chime in. There are some service providers to financial institutions that are themselves financial institutions. And there was a recent case brought by the FTC that I think reinforced that point. Some people missed that. But even if you're going to share data with a service provider, as under Gramm-Leach-Bliley, you have to have a written contract. It has to have controls about their use of the data. So that sharing, their receipt of that data, is governed by the Gramm-Leach-Bliley Act. So when they receive that data, so long as they're using that data in accordance for the purpose that they got it under GLB, it's still governed by GLB. So that data would be exempt. Now, if you're a bad guy and you take the data and you do other stuff with it, well, you're not only violating GLB, but you're also, now in the middle of CCPA and a whole bunch of other problems.
So you really need data mapping at the lender and the vendor level.
Yes,
if you're the
right.
lender.
If you're a vendor, you want to know what you're getting from the folks that are sending you the data, why you have it, and be able to justify that it's covered under one of the exceptions. For example, if you're going to say, I don't need to do X or Y or Z with this data because this exception applies, you have to have something that shows that that's actually the case.
So along those same lines, if we talk about, when we talk about data in this instance, it's usually very structured, formatted. You've got a place to house it in your system, or the third-party vendor, like John's case, would have a place to house it. But what about unstructured data? So you've got data that you've developed, and your collection agents are entering comments into notes in your system of record. It's unstructured, but technically it may fall under that deletion rule. Any advice there? Or?
Well, I think that is one of the things that a lot of companies are struggling with. Right. And we saw this with if you had a data breach, for example, of unstructured data, trying to figure out what data elements you have in it, what was the information that was breached. I think you were talking about copy and paste. That's my least favorite thing too, for exactly that reason. Because if you have some customer service people just copying and pasting large swaths of personal information, now what may have seemed a small issue is now a much bigger issue because you have social security numbers and things like that. So having better controls about what people are allowed to do in those kind of free-form fields is going to be important.
Right.
But also having a way to access it and look at it. So looking at your systems, and do you have the ability to search?
Right.
If you had a problem, how would you be able to figure out what's in there?
And it's not a go-forward law. It goes back to whatever data you have in your system, right, from whatever it was generated?
Yeah, it does,
Right.
with the caveat that if you don't need it, delete it, because
Right.
then it's not covered anymore. And along those lines with data breaches too, go back to the letter of the law and see what the categories of personal information that are covered under the data breach. And if you don't need to collect that information, don't collect it and don't hold on to it, because then should your information, your systems get breached, you're not opening yourself up to the liability of a private right of action.
Right.